Hi everyone, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Today, I'm continuing the set of videos that focus on how marriage and divorce affect estate planning. Marriage gives spouses certain legal rights, and it is important to be aware of what comes along with marriage and what does not. In North Carolina, there are only two ways a legal marriage can end. One, death of a spouse, or two, separation for 1 year without a period of reconciliation, followed by an entry of an order for divorce. The divorce rate in the United States is rising, and the North Carolina requirement of physical separation of a married couple for 1 year before a divorce is granted results in some important legal implications. Separation and divorce have different effects on one's estate plan. So let's talk about how each affect your estate planning documents. First, for financial power of attorneys and healthcare power of attorneys, they would terminate upon death. But during separation, there is no effect on the documents. So if you named your spouse, then they could still be the agent to make financial and healthcare decisions for you if you lack capacity. Upon divorce, if you named your former spouse as your agent, their authority under the document terminates. However, you should execute a new power of attorney. Next, for life insurance and retirement accounts, upon death, if you named a designated beneficiary, the funds go to that beneficiary. If you did not name a designated beneficiary, then the funds go per the terms of your estate. During separation, there is no effect. So if you name your spouse as the designated beneficiary and you pass away, then those funds will go to them. Upon divorce, generally there's no effect, and the former spouse is not usually automatically removed as the designated beneficiary. So if you named your now former spouse as that beneficiary and you pass away, the funds would go to them. If you die intestate, meaning without an estate plan, if you have a spouse, then they are provided for according to the North Carolina intestate succession statute. During separation, there's no effect on the intestate distribution. So if you die, then your spouse would receive a portion of your estate. Upon divorce, the former spouse loses all rights in your estate. If you die with a will or a trust, then your estate would be distributed per the terms of that document. During separation, there's no effect on the document, so if you die, your spouse would receive a portion of your estate. Upon divorce, the entire document is not revoked, but all provisions in favor of your former spouse are revoked. However, it is important to note that provisions in favor of your former spouse's relatives, if any, would still remain. Remember, North Carolina requires physical separation of a married couple for 1 year before a divorce is granted. In that 1 year, there are really no changes to your estate planning documents unless you take action. Even after the divorce is granted, estate planning matters need to be addressed. So contact me and we'll work through creating or updating your estate planning documents. That's it for today. I hope you liked this video and found it helpful. Please share with anyone you think needs to hear it. Again, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Have a great day.